Hello everyone, welcome back to A Tejswi IP Show. I am your host Prateek Raj, where we explore everything you need to know about intellectual property. In today's episode, we are diving into a crucial topic for anyone looking to secure a patent: how to draft a strong patent application. Whether you are a startup founder, an inventor, or a professional advising clients, drafting a solid patent application is key to protecting your invention and maximizing your legal rights. So let's get started. So why is drafting your patent application is so important? See, a patent is a more than just a legal document. It's a tool that provides you with a monopoly over your invention for a certain period, protecting your idea from being copied. However, this protection only applies if your application is well written and comprehensive. Now let's talk about essential components of a patent application and how to draft them correctly. So number one is title of the invention. The title of your invention should be very short and specific. Avoid vague or overly broad title. For example, instead of calling your invention mechanical device, be more specific: a solar powered mechanical arm for robotics. It is more precise. The next one is the background of the invention. This section explain the technical field your invention belong to, and why it's needed. You want to address the problem your invention solves. Don't get too technical here. Focus on clarity. What gap in the market does your invention fill? Make sure this is clear because it sets the stage for the rest of your application. Number three is summary of the invention. The summary provides a high level overview of your invention, and it's a key feature. It's like an elevator pitch in your patent. So keep it concise but comprehensive enough for someone to understand the broad strokes of your invention. Number four is detailed description of the invention. Here is where things get interesting. The detailed description is the heart of your application. You need to describe your invention in enough detail so that someone skilled in the art, basically an expert in the field, can replicate it. Be sure to include technical drawings, diagrams, and flowcharts where necessary. The more specific you are, the better. And number five is claims. This is the most critical section of your patent application. The claims define the scope of your patent protection. So, what exactly you are claiming as new and inventive? You want to draft both broad and narrow claims. Broad claims cover the overall concept of your invention, while narrow claims focus on specific features, like strike a balance too broad and the patent office may reject it; too narrow and you risk not getting adequate protection. Okay, so one common mistake in the claims section is not thinking about potential workarounds. When you are drafting claims, try to think like a competitor. Would they be able to modify your invention slightly and get around your patent? If so, draft your claims accordingly to close those loopholes. So, number one is drawing if applicable. If your invention involves a physical product or a complex process, you should include a technical drawings. These drawings helps illustrate the parts and function of your invention. Keep them clear and labeled with references to specific parts mentioned in your detailed description. Number two is abstract. The abstract is a brief summary of your invention. It's usually not more than 150 words and gives the reader an idea of what your invention is about. It's important because it can help attract attention during searches. Okay, so how do you ensure that your patent application is rock solid? So here are some additional tips. Be specific and detailed. One of the biggest reason patents get rejected is the lack of detail. Don't assume the patent examiner knows what you mean. Spell it out clearly. Next one is avoid ambiguity. Vague language is your enemy. Be as precise as possible. Work like some may or possibly, sorry, words like some may or possibly can weaken your claims. Okay. Uh, Next one is think long term. Remember, patent lasts for 20 years. You want to ensure that your claims cover future improvements or variations of your invention. Consider the direction your industry might go and how your invention might evolve. Next one is hire a patent attorney. While it's possible to draft and file your own patent application, it's highly recommended to consult with a patent attorney or a IP firm. They can help you avoid costly. You can consult us also. They can help you avoid costly mistakes and ensure your application is airtight. A question I get asked frequently is whether you should file a provisional patent application or go straight for non-provisional application. So here is a quick breakdown. So let's get started. A provisional patent application is cheaper and easier to file. It gives you 12-month window to develop your invention further or gather funding. However, it doesn't turn into a patent unless you file a non-provisional application within that 12 months period. Uh, a non-provisional application is a full application that gets reviewed by the patent office. It's more comprehensive and formal, but provides immediate protection upon approval. In many cases, a provisional application is a good first step, especially if for startups or individual inventors who need time to develop their product. But make sure you follow up with the non-provisional application in time. All right, do a quick recap for today's key points. A strong patent application starts with a clear title and well written background. Okay, the claim section is critical. Draft both broad and narrow claims to cover all aspects of your invention. Include detailed description and drawing to support your application. Consider filing a provisional patent to buy for development, but don't forget to follow up with non-provisional application. And there you have it. Drafting a patent application can be complex, but by following these steps, you will be on your way to protecting your invention. If you are unsure, always consult with a patent attorney or IP firm. They can make the process much smoother. Trust me. Thanks for tuning in today's episode of A Tejswi IP Show. If you found these tips helpful, don't forget to subscribe and share this podcast with others who might benefit. Stay tuned for tomorrow's episode where we will dive into another important aspect of intellectual property. Till then, have a good day. Bye.